He grew up here in Chillicothe and graduated from Duke University, where he obtained his law degree from Washington State University, or Washington University, St. Louis. He now spends most of his time managing his family's ATFS certified tree farm, which straddles the Ross and Benton County lines. Without any further ado, Jim.
All right, well, thanks so much. I can't see everyone, but glad to know you're here. Mark and I had some fun putting this together, and we're not only going to focus on timber theft, but also kind of the closely related timber trespass issue. I'm going to introduce our one participant who couldn't be with us today, but is a large reason why we're here, and that's the gentleman on the screen, Mr. Robert Silcott. He was caught with a trail camera cutting down trees on private land in Benton County. That's the trail camera shot. And if we'll go next, we'll see where he is today. He's in the Circleville Correctional Institute. He was sentenced to 14 months in prison in Ross County Common Pleas Court last October. And aside from a few misadventures we'll get into later, that's his current home. In the last 2 or 3 years, timber theft has become a big problem in southeastern Ohio. Let's go to the next. And this is the sort of thing you may see. Somebody with a pickup truck and a walnut log driving down the freeway, or not even the freeway. What do you do if you see that? The people at DNR law enforcement who are responsible for these sorts of problems on state forest do advise that you call the police, the sheriff's office, because of this. Now, in many instances, they can stop them because they're doing something traffic-wise that isn't good. It gives them an excuse to stop, and then they can go from there. But next, this is what a real logger looks like. These are the big truck, how logs are carried typically, not somebody with a log in the back of a pickup truck. Next. So how are they, these thieves, removing and transporting these logs? Trucks of any size, trailers, chains, all sorts of things that we've seen. Next. Here's an example of some of the next couple of photographs show examples of some of the conjured up equipment that they've been using to haul these logs out of either the state forest or private land. David, some specific instances of trailers and handmade winches, and but this is, if you see something like this, this is not a legitimate logger. This is most likely a thief. Next. Here's a few more. I'm sure everyone will be surprised to hear next that what is the driving force here is money. For these timber thieves, it's a crime of opportunity, and it's really enabled by sawmills in Ohio who have no regulations in terms of who they buy from, what they do. And so a guy like Robert Silcott in a pickup truck with a walnut log in the back can show up at a sawmill in Ohio and walk out with $500, $600,000 or $500, $600 in cash, and it is and it's easy to do. Next. The reason that walnuts in particular are easy targets is that they require very good soil, which is tends to be in flatter areas, which tend to be where roads are. So a thief driving down this country road in Ohio could see this big walnut tree right next to the road, and it's a real opportunity to, take it, whether it's right by the road or not too far off the road. Next. So when someone like one of these thieves takes these logs to a sawmill, this is an example from DNR law enforcement of an actual type of paperwork that they get. And you can see that it's not full of details. It's just something scribbled on there about footage and the amount that they're being paid. And we're gonna contrast this log sheet with some other more typical log sheets a little bit later. Next. So how is timber theft discovered? The obvious thing is there's a stump, but also drag marks on the roads and hung trees and treetops, and we have some photos of these. Next. Obviously a stump, and you can see sometimes from a distance if a tree is sort of fallen down or not. Requires a little bit of investigation. Next. Now this is back. This is a log on, actually a walnut log that was cut down by Mr. Silcott on my property in January of 2018. And the reason that we found out about it was my neighbor was driving along the road, and it looked like he thought maybe it had been blown down in a storm or something. But our next door neighbor had had a couple walnut trees stolen the week before. So we immediately investigated and found that a nice 18-inch walnut tree had been cut down on my property and cut into saw logs. But fortunately, it had been left there. And then my neighbor discovered Mr. Silcott and another person in a stolen dump truck right by the side of the road where they apparently come to retrieve it, and scared them off. Next. But other signs of things that thieves may be doing things they shouldn't in the area: chain drag marks on the left and a chain burn into a log are things to look for. Next. Drag marks, and again, the tree tops from a distance. If you see tree tops and there hadn't been a storm lately, that should tell you something. Next, please. So there's been to give you an idea of the scope of this, just in 2 years of 2017, 2019, here's a list of folks who've been convicted in different counties in Southern Ohio for doing exactly this: coming onto someone's property, stealing logs, or both state and private, stealing mostly walnut but also white oak logs, and selling them for cash to sawmills. There's a long list of stuff, and I spoke to DNR law enforcement yesterday just to kind of see what's been going on. And of course, Mr. Silcott is in jail now. Some of these other people are out or in jail. And because of the pandemic, logging prices have fallen quite a bit. And so they're not seeing as much activity. There is two thieves that are pretty active right now in Southern Pike County. To his knowledge, it's just been on state forest land, but if they can steal there, they'll steal anywhere. And they haven't caught him yet, but they have a pretty good idea who it is, and they're on the trail. But as long as, you know, there's an opportunity to do this to make some quick money, you know, people are going to do it. And next, please. Last year, there was a task force of representatives of a lot of law enforcement agencies to kind of get together and talk about the problem, make people in law enforcement more aware of the problem, share information. But it's, as you can see from the number of agencies involved, it's very difficult under the current system to effectively police this problem. Next. And, you know, so these are the problems that really confront prosecuting tree theft cases in Ohio. The number one problem is apathetic law enforcement. And, you know, in fairness to law enforcement, I mean, their resources are stretched and they're stressed like so many other public agencies with the pandemic. But even before the pandemic, they just don't understand this as a priority. And the argument or the point that I try to make whenever I'm talking to someone from law enforcement is, if I have an automobile in my driveway and somebody comes onto my property and hot wires it and takes it, that is something that you would go after, absolutely. But if someone comes onto my property and cuts down 2 or 3 trees that are worth collectively over $1,000, $2,000, it's like, well, it's just a tree. Well, it's no different than coming onto your property and a hot wiring a car and stealing it. And they seem to, you know, they kind of nod their head and understand that, but yeah, it's hard to get them really pumped up about doing this. Now, we were fortunate in Ross County to get the prosecutor to go after Mr. Silcott. He took walnut trees from my neighbor. He cut down one on mine. But most importantly, he cut and stole trees at both Scioto Trails State Park and Tar Hollow State Park. And the DNR law enforcement people who were responsible for that were, you know, Johnny on the spot in terms of investigating, getting stuff together, and we kind of combined all the cases. But the other problem you have is multiple jurisdictions. So I'm telling the Ross County prosecutor that Mr. Silcott was arrested in Vinton County, which is next door, and that's where the trail camera photo that you saw came from. And well, it's one county over. It's not of my concern. There's nothing I can do about it. Another problem or issue are the criminal penalties. It's a misdemeanor. There's no specific statute for timber theft, unlike a lot of states. It's sort of dumped in with any other kind of theft. And it's a misdemeanor unless the value is above $1,000. Now, if you get, you know, 2 or 3 nice trees, you're over it. But my neighbor was over 65, so it's a felony if there's a theft of anything from someone who is over 65. So I've only got 9 months to go there, so I won't have to worry about that with any trees of mine that might be stolen moving forward. And then the final, and I would argue most significant problem in prosecuting timber theft cases in Ohio are the uncooperative sawmills. Let's go to the next one, please.
This is where I get a pipe up a little bit, Jim.
And I'm going to let Mark Rickey talk about things you can do to prevent this sort of problem, and then we will revisit the sawmills.
Yep. Thanks, Jim. And so what we're going to talk about a little bit is how to deter some of this, or how to set yourself up for when it does happen, the best avenue you can go. And again, this is kind of nice in a virtual setting for me because it doesn't necessarily have to be all about a landowner. As a citizen, there are things you can do as well, and we'll go over some of that. So we'll get started on how do you go about taking these preventive steps. Well, first thing is that we always recommend is permanently mark your boundary lines and paint, etc. This one that I'm sharing with you is probably one of the best, most creative anyway, boundary markings that I've seen in my career. And it is on a public entity's property in Benton County. And no, that's not Division of Forestry. But anyway, this is a little more elaborate. All we're shooting for is some paint. Paint on the trees like this, and I get from landowners that I work with all the time. Hopefully you guys can see my mouse here too. The next paint marker is up here in the brush. But this is a typical scenario that you're seeing on this picture of when a timber harvest comes right up to the boundary. And luckily in this case, they did not remove the boundary trees. And we'll hit on that a little bit here too. But this is a prime example. When you paint the boundaries, this might have been fully canopied woods that was shaded off nice and open. After a timber harvest up against it, it gets considerably thicker. So again, if you walk out in your woods and you notice all your trees you painted are gone, it's pretty obvious you've got a problem. So you'll see things like this as well. This is a interesting white oak that was on the boundary. The little blue ribbons at the bottom of it are the metal fence that went through the tree. And what you see sticking out of the tree is actually the smile cut, or the wedge cut as they call it when they're dropping the trees. And you can clearly see that it's pointing to one direction of where they're going to fell that tree. The legal timber harvest was on the opposite side of that tree. So we're getting ready to drop the tree into the area they were trespassing to begin with. So again, these things show intent, which we will talk about later. And certainly that will come up in our later presentations with Peggy Kirk Hall and also Amy Milam with the Farm Bureau. They'll be talking a little bit more about things like criminal mischief, criminal trespass, aggravated trespass, theft. These are all terminologies that I'll leave to the legal folks to help explain to you. But again, frequent your property and your boundary lines. Make your boundary lines well known, not just to yourself, but to everyone. Make sure you know what your neighbors are doing and be familiar with their land management activities. If they're having a timber harvest or something, it's not a problem to go over and introduce yourself to operators or buyers or the landowner themselves, and make sure to clearly communicate things like how you want the boundary line trees treated. And that's probably one of the beginning problems that we have is, again, who owns what and how you treat it. And again, the legal folks behind me can talk about some of this, I hope, as well, because they will be talking about the fence line law of Ohio. And you'll hear things about that here in a little bit. Basically, a joint shared property is what a boundary line tree is. So that does not mean that you own it or your neighbor owns it. It means you own it jointly. So in theory, you cannot remove it without both landowners' permission. Down this way, I hear it a lot. We can take every other tree. That's kind of a weird way of doing it, because who selects the tree? And it gets into a mess. Best advice I can give you is do not cut the boundary trees that are marked unless you have a game plan of something to replace it with. If somebody's going to take them out and build a nice, good fence and everybody's in agreement on both sides, that's fine. So, all right. So again, be aware of activities in your immediate area. And everybody kind of looks at me weird and says, well, why do you need to pay attention to what's going on down the road? Well, usually when people are in an area, they kind of tend to work in an area. And it's nice to be familiar with who's doing what operation and what level of degree it is. And quite often it's nice to find out who they're cutting on or whatever and talk to them and make sure that landowner knows. Because again, there's where you can run into things like I have in my career. Do they even know they're having their trees cut? And sometimes, unfortunately, the answer is no. So again, next step to take, keep good people around. I always tell my landowners you have two options in this world. You can keep good people around or bad people around. Because when you own land, pretty much there are going to be people in and out of it on a regular basis. And again, I know later Amy will be speaking about the recreational user law, and there will be some good information in there too, help you understand the difference between an invited guest and a trespasser and things like that. Very, very important information as a landowner. So keeping good people around, not necessarily that it's guaranteed to be good people, but family, friends, hunters, your forester. Soil and water conservation districts, natural resource conservation service, Division of Wildlife, people like this that will be agents for agencies that you've invited to your property that will be around at times during the day and so forth when you're not. A lot of landowners are out-of-town landowners, and I have actually witnessed several occasions where timber thieves have targeted folks by looking up their address and so forth, and figuring out where they live and how frequent they are on the property. And as Jim would attest, a lot can be done in a day, let alone in a week or a month. So just keep that in mind. And when these agency folks are dealing with things on your property, they're kind of coming and going, and they would help be your eyes and ears. So utilize that to your advantage. So here's the next big step to take, which I'm really proud of this landowner. The picture to the right was a nice plantation or a grove of walnut. I encouraged the landowner for quite some time to get those inventoried by a professional forester. And I'm proud to say today that that has been done. So every tree there you see has a marking on it of where it was measured. The diameter is measured, the height is measured to get the volume in the tree that's available at that time of what it was. And this is done by species, and everything is cataloged. So again, if it is stolen, it's almost like having a serial number, but it certainly gives you a volume which you can set a value to then to begin to estimate the damages. So this is certainly something to do on your high value trees, and if they're easy reach, certainly those need to be addressed and taken care of. Easily done with a forester. We do maintain lists of professional foresters to be able to do such a work, and I highly encourage it. It's well worth it. So the next step to take, and everybody says, well, you know, trail camera, that's too easy to get around. Well, yes and no. What I encourage you to do with the trail cameras are get a little more creative. And today they make some really nice ones that are things like satellite photos, and it'll take pictures and send them right to your cell phone or to your computer. And as soon as the picture is triggered, you've got a record of who's there. Be creative though. And you'll see this. I know this is one of Jim's favorites. That's the same picture we showed earlier to start, but the next picture of this gentleman, Mr. Silcott, is right here. This is a trail camera in his hand, if you guys can see my mouse. And he's getting away. The only problem is he didn't realize that somebody was smart enough to set up another trail camera facing the first one. And I've done that myself, and it works very well. So sometimes you just can't make it up as good as the truth. So here is Mr. Silcott's business card. I'm not sure if it was a Freudian slip when he put on here Rob's Timber, but he certainly does. Licensed and bonded and insured. To the best of my knowledge, he would be the first licensed timber buyer that I've ever seen. We do not have a timber buyer licensing in Ohio. So he is cutting edge. So I'll leave you with this little. So with that, I will leave you guys with one more parting shot here. Hopefully you can see me. So good boundary painting is the beginning of this. All your problems start at the boundary line. So make sure you get a hold of your deed and a survey and figure out where your boundaries are. Talk to your neighbors, ribbon them first, then paint them. And if you want all the instructions on how to paint boundaries, you can go to the Southeastern Ohio Woodlands website that this is through. From earlier this year, we did this presentation on how to mark the boundaries, and all that information is there. If you can't find it there, get hold of Dave Apsley or myself, and we will certainly get it to you. So I will see what we got here next, and that turns us back over to Jim, and I will be around for questions later as well as the rest of the panel, I do believe. Jim, it's all yours.
All right. Well, thanks, Mark. Going to the point of Mr. Silcott and law enforcement being sometimes a little apathetic. He was sentenced and sent to Pickaway County or Pickaway Correctional Institute in October of 2019. He had a pending case in Vinton County, and he had a hearing in February. And so they went up and picked him up and took him to his proceeding or pretrial or whatever it was in Vinton County. And then Vinton County let him go. They didn't take him back to the prison. And 2 or 3 weeks later, he was caught stealing walnut trees again in Ross County by a landowner. The Ross County sheriff was called. They picked him up. It was a misdemeanor, and then they released him. So he essentially had and then about 2 or 3 weeks later, somebody from DNN law enforcement saw him with a walnut tree in his pickup truck parked behind or next to Pike Lake. And they picked him up, and finally, after a 7-week vacation, they took him back to Circleville Correctional Institute. But that's the sort of problems that you run into in holding these people accountable. But it also goes to the excerpt from the music that was just played. I mean, these people are not going to stop. They're going to continue to do this time and time and time again, whether they're caught, whether they're not. They're just going to play the system as long as they can. So the final step to take as a landowner, if something like this happens to you, is to insist upon a police report. Call the sheriff, have them come out, have them document, what happened. Moving next, please.
Sure, Jim, if I can chime in real quick. With that, going back to the boundary marking, one of the first steps of dealing with any of this is, did they knowingly cross a boundary?
Yeah, right. And it underscores the need to have your boundaries very, very clearly marked. So what some of us are advocating, which we believe would really put a dent in this problem, and it really was the idea of the guys or the professionals that work for DNR law enforcement, because of a lot of the problems they've encountered in trying to get information to prosecute these cases. Many of you may or may not know that there's a scrap dealer law in Ohio, and it's been on the books for 5 or 6 years. It was enacted in direct response to all the thieves that were stealing copper and other valuable metals off the homes and things, and then taking them to a scrap dealer and converting them to cash. And it has, there's really go to next, please. What's really good about it is that it requires a scrap dealer to keep records of each sale. Everybody that shows up with scrap, they have to have a copy of an ID, which the dealer has to make a copy of it. And so if we just applied this to sawmills, all they would have to do is record the sale, get a copy of the person's ID, document the details of the saw log, get their license plate number, and a photo of the seller. Next, please. And, contrast these documents from the ones that we saw from the other logging company earlier. This is what the sawmills, this is the level of detail that they typically provide and do with respect to sale. And actually, this guy was someone who was convicted, but they document the grade, the number of square foot, the cost, etc. Just and they do it with they got computer software. It's not a big deal. They do it. And the reality is for walnut logs and white oak logs, which are likely going to be resold, they have to have this documentation in order to resell it. So they already are doing it for the most part. And next, please. So if we just expanded the scrap dealer law to sawmills, what it would add is A, it would make records available to law enforcement. So the way it works with the scrap dealer law, if law enforcement comes to see a scrap dealer, they have to turn the records over. They don't have to scramble around and get a subpoena. Right now, a sawmill can tell somebody from law enforcement, no, I'm not giving you these records, go get a subpoena. And that's can be a very cumbersome process. And the scrap dealer law requires the records be made available to someone, the victim. So if it was your logs that were stolen and you find out the sawmill, you can get the records that would help you with a civil action down the road. The other part of the scrap dealer law, if it was expanded to sawmills, it's really interesting, is it has a known thief list. So what does that mean? So the scrap dealer law requires each county law enforcement to create a known thief list and provide it to the sawmills. And it's illegal for a sawmill to buy anything from anyone who's on the known thief list. Now, for civil rights, there are some questions about that. But if you're on the known thief list and you find out you're on the known thief list, there's a short procedure for you to get off of the known thief list if you shouldn't have been on there in the first place. But at a minimum, if, like Mr. Silcott, who has a conviction for timber theft, he could never get off the known thief list. And it would be illegal for any sawmill in the state of Ohio to buy saw logs from him. And think of what that would do. What it would do is that anybody that's convicted for timber theft and is on the known thief list cannot no longer has the ability to convert logs to cash. And more than anything else, if that was done, this problem would disappear. All right, next, please. So we're going to talk about timber trespass. We're going to, and the question is what's the difference between that and what we were just talking about? Well, what we were talking about under timber theft is sort of the person who, from day one, that's all they wanted to do is just steal trees and convert them to cash, and there's no ambiguity there. But when you have loggers who are working for someone on property next to yours, who come over the line and cut your trees, it's a little different situation. There's a whole range of what people can be doing. But the problems with this issue is, again, if you call law enforcement out, they'll tell you it's a civil matter. And I think in many instances, they're right, because if there are ambiguities on where the property line is, someone from the sheriff's department can't resolve that on the spot and then cite somebody for going over the line. And what typically happens is, gee, I thought the line was here. Well, no, it's there. Well, I thought it was here. And it all goes back to, if your property line is clearly marked, you're not going to have these problems. The other issue is the finger pointing between the logger and the adjacent landowner. So the adjacent landowner hires the logger, he goes over the line, cuts your trees, you start yelling and screaming, and the first thing he's going to do is, well, the adjacent landowner told me that, even though this tree is marked, that this special section over here that had these great walnut trees or white oak trees was not, and was his. And then the adjacent landowner is going to say, no, I told the logger exactly where the line was, And with this finger pointing, if you want to seek damages, who do you go after? So next, please. So this is a typical timber trespass scenario based on an actual case that I tried in Ross County. And the dotted line there is the property line. And the property to the left of the dotted line was owned by my client. And the property to the right of the dotted line was owned by Jason, their neighbor. And there was along the property line, there was like every 50 feet, there was like a stake with a piece of red tape that you could hardly see anymore. So it wasn't very well marked, but there was a very pronounced ravine up at the top. And then above the ravine, there was another flat area. And so what the logger did is he cut everything above the ravine. The clients were out of town for Christmas. They came back and heard saws going off and were horrified to see that all their beautiful mature timber was cut above the ravine line. And of course the logger said, hey, you know, the adjacent landowner told me the ravine was the line. And the adjacent landowner said, no, I never said that. I told him that this dotted line where the stakes were and it was straight was the line. So what we did is we filed suit against both of them as defendants. So in a civil action seeking damages. So what is your civil remedy if somebody comes across the line and takes your trees? Next, please. Well, you at least have a claim for trespass and conversion. Now, those can also be criminal liability situations, but for purposes of civil litigation, that is suing somebody for damages, if somebody comes across your property line and does something, they're liable for trespass. And obviously, if they take something that's yours on your side of the line, absolutely they're liable for conversion, which is just a civil remedy for damages for stealing. Now, Ohio has a triple damage statute, which we'll get to in a second. But before I get to that, you can get triple damages if you can establish that the person took your trees, were reckless. And the courts have struggled kind of with what that means. But it generally means that it wasn't negligent, it was worse. They really absolutely should have known that they were crossing the line. Now, to just digress for just a second, Ohio has a purple paint law that's been proposed. It hasn't been enacted yet. It's in committee at the General Assembly. And a number of states have, it follows a number of states like Pennsylvania who have enacted it. But what it says is that if you use purple paint on your trees at your property line, it has to be purple and it has to be, you know, there's some specifications on how much you put on, how big the spot has to be, et cetera. It means that it's this, legally it means the same as if you had a no trespassing sign there. So it's the same as if you had a no trespassing sign, private property, no trespassing, here's the line on every tree that you painted purple. And so if somebody goes across one of those lines and cuts trees, there is no ambiguity. It is absolutely reckless. Next, please. So this is the a special statute that's been on the books for a while, which enables someone to recover treble damages, that's 3 times damages, if they can establish, we go to the top, that someone, quote, recklessly cut down, destroyed, girdled, or otherwise injured tree, you know, in other words, if they recklessly cut down your trees, if they recklessly went over the line, cut down your trees, you're entitled to recover in the civil action triple damages. Next. So how do you measure these damages? So obviously, the first and major damage is the value of your trees. So the way the law has evolved is that you can pick one of three. If you have either you can get a real estate agent who will tell you to testify as the before and after value of the land, which can get you some compensation for lost aesthetics. So if your land before the tree was cut was valued at X, and after the trees were cut, it's valued at Y, your damages is the difference between those two. A second way to do it, and it's one or the other, is stumpage value, and you get a forester who can come in, look at the stumps, count the rings, measure them, and they can extrapolate from that the size and the value of the tree that was taken. Or in very special circumstances, generally like if this is you're in the city or you're in the suburb and these trees are ornamental and they're, you can get a landscape contractor to say, well, this was a 15-foot tree, it's $150 to replace it or what have you. But for woodland landowners, that's, not typically the route you're going to go. You're either going to look at before and after value of land or stumpage value. And then don't forget, in addition, because oftentimes when someone goes over the line, they tear up your land. You might need to get an excavator to kind of restore it, to kind of put it back the way it was as best you can. That's an additional damage that would be recoverable times 3. So going back to our case, you still have the problem, or we did, of the finger pointing on who's really responsible. I mean, the logger's saying the landowner told him the line was the ravine. The landowner's saying, no, I didn't tell him. So, there's a problem there on who's going to end up paying. And so what we did in this case, and it's something to be mindful of, to solve the finger pointing problem, is, of course, we sued both of them. And the law we argued, which the court agreed with, was that essentially what you had here was a partnership. So the logger and the adjacent landowner had a typical arrangement that's typical in Ohio, where the landowner provides the land, logger cuts the trees and takes them to the sawmill. He was going to get he'd get 2 checks, 50-50, one for him and one for the landowner, and give the landowner his checks. Now, aside from the obvious problem of trusting someone you barely know not to cheat you under such an arrangement, the fact of it is that the law argues or recognizes that a partnership for a specific purpose, a partnership is simply a carrying on business for profit. And a joint venture is one where it's just kind of a partnership where it's just, one specific purpose. And, but the key is that if it's a partnership or a joint venture, either participant, each participant is liable for whatever the other one did. So like if you have 2 guys that have a partnership running a store and one runs up a debt with a vendor and it isn't paid, well, both of them under the law are liable for paying the vendor. So we argued that since it was a joint venture, both the landowner and the logger were equally liable for whatever either one of them did. And the court agreed with us, and there is precedent in Ross County Common Pleas Court for that proposition. So we were able to recover from both of them. But there is another implication here, and that is if you enter as a landowner into an arrangement with a logger in which you split the proceeds from the sale of timber, you are liable for whatever the logger does. So think about that. So if the logger leaves his equipment there over the weekend on your land and a child comes over and starts playing with it and is injured, you're liable. If the logger doesn't pay workers' comp premiums and one of its workers are hurt, you're liable. So it just underscores the need to be very careful in entering into very specific contract whenever you sell your timber, hopefully with the help of a consulting forester, as opposed to some of these loosey-goosey things that we see, because otherwise you risk getting into bed in terms of economic risk with somebody you barely know.
Jim, if I can interject there real quick.
Sure.
Dealing with foresters, there are multiple levels of forester in Ohio, and going back to having a timber appraisal done or a valuation, especially in a theft case, you do not necessarily want to get a forester that is hired through the industry. In other words, a sawmill can employ a forester. You generally do not want to get them to value what is stolen. They may have had a role in dealing with that logger or that whatever timber thief at that point, whatever, at one point or another. So just to keep things straight, you want to hire a consulting forester who works strictly for you in that case that is unrelated to the transaction of the timber being stolen.
Yeah, absolutely. And so I'm going to end with a plug. By way of background, Ohio, 33% of Ohio is covered in woods. 82% of that woods is owned by private landowners. And we don't have a voice at the General Assembly. But we're going to start doing that. So through the Ohio Tree Farm Committee, we're starting an Ohio Woodland Owner Advocacy group. Very simple. If you're interested, email me. There's my email address. Email me your email if you're interested in being on it. And then we will contact you if there's an opportunity to send an email to your state representative on something, legislation of interest to, and that's important for us, for Ohio woodland owners. We have our own interest, not necessarily the same as the Ohio, the logging industry or the furniture industry or what have you. And obviously you're free to participate or not in any of our initiatives. But what we would envision is if there's something coming up, we'll send you an email that this is why we are promoting this. This is why we think it's important. Here's your representative. Here's a sample letter. Obviously, if you don't like it or aren't interested in it or want to revise it, you can. But if you're interested in participating, on a kind of an item by item basis, as you deem it appropriate, or if it's of interest to you or not, just send me your email address. I've got 38 already, and I'm trying to get as many as I can. That's it.
Thanks. Thanks, Jim and Mark. We greatly appreciate it. We're running a little bit behind on time, so we do have one person with their hand raised, James. So I'm going to let them ask a question, and in the meantime, if Peggy and Amy are on board, you guys can go ahead and load your PowerPoint. And while that's happening, we'll let Jim and Mark take that question. So James, your mic you should be able to turn your mic on, and you can ask your question.
Can you hear me? Yes, can you hear me?
Yes.
Well, this is Joanne and James Basie. Okay.
Okay.
So talking about the expand the scrap dealer law to sawmills, why haven't y'all done something to get this accomplished?
Well, because we just focused on it, and we're hoping to get a group of owner advocates that can help us do that. It's not easy to get something through the General Assembly, but it's something that we would like to try to do.
Okay. Okay, thank you.
So I'll be looking for your email address.
Thanks, Mark and Jim, again. I'm going to turn it over to Ross Meeker from Ross County, and he's going to introduce our next two speakers. So, Peggy, if you want to go ahead, you can share your screen.
Actually, Amy will be sharing her screen first. Yes.
Okay,
Alrighty.
It looks like she started. We're just seeing a blank black screen right now, Amy.
Alrighty, guys. I want to take a second and introduce our next couple of speakers. First up is going to be Amy Milam. Did I get that right?
That's right.
All right, awesome. Amy Milam, she's with the Ohio State Farm Bureau, and she's the Director of Legal Education and Member Engagement at the OFBF. In her position with Ohio Farm Bureau, Amy provides legal education and information on agricultural issues to Ohio Farm Bureau members, monitors legal cases important to agriculture, and reviews proposed legislations at the state and federal levels. Amy received her Juris Doctorate degree from Capital University's Law School in 2007 and a bachelor's degree from Ohio University, where she studied communications. Before coming to Ohio Farm Bureau, she was an associate attorney at a law firm where she practiced real estate law. Ohio Farm Bureau is a grassroots membership organization that works to support the state's food and farm community. The organization helps its members engage in policy and communication activities to improve their communities and provide a wide range of member benefits. And along with her, we will also have our in-house legal consult, Dr. Peggy Kirk Hall, and she's the associate professor and field specialist here at OSU for agriculture and resource law. She is a graduate of the Ohio State University and the University of Wyoming College of Law, where she served on the Land and Water Law Review. She's a past president and board member of the American Agricultural Law Association and a past chair of the Ohio State Bar Association. And we're super glad to have both of them with us here today. Without any further ado, Amy.
All right. Thank you, Ross. And can everyone see my screen now? Okay, very good. So today I want to take some time to talk about a protection in the law that can provide some comfort or reassurance to, woodland owners or other landowners who let people come onto their property to do things such as hunt or hike, camp or fish, to provide some reassurance to them on limiting their liability to someone who may get injured doing some of those activities. So first of all, just an overview of what we call the recreational user statute in Ohio. Again, it was created to allow a landowner to receive immunity from liability for injury sustained on their property by a recreational user of that landowner's non-residential property. The purpose of this, again, was the legislature enacted this to encourage owners, landowners who had land that's suitable for recreational outdoor pursuits to open up their land for use by others who may not have that same access without the fear of legal liability for injuries. Again, with an immunity statute such as this, what's really happening here is the statute is changing the general rule that the landowner would owe, a specific duty of care to that person visiting the property for that recreational use based upon the type of visitor that they would be. So in general, we have different duties of care to people who come onto our land, whether they're a business invitee coming on to basically serve a business purpose, whether they're a licensee or social guest, and even to a trespasser, whether a known or unknown trespasser. So again, the recreational user statute changes that general provision. Instead, what it states is that no owner, lessee, or occupant of premises owes any duty to a recreational user to keep the premises safe for entry or use. That owner, lessee, or occupant does not extend any assurance to a recreational user through the act of giving permission that the premises are safe for entry or use. And that owner, lessee, or occupant does not assume responsibility for or incur liability for injury to the person or property caused by an act of a recreational user. So pretty broad language there by the General Assembly. Now, there's some very specific key points that must occur here, some factors or conditions that must occur here for the immunity to apply. So kind of first and foremost, the person who's using the landowner's property must meet the definition of a recreational user of that property. Now, our statute actually provides some pretty specific examples of recreational use. It's, entering upon the premises to hunt, fish, trap, camp, hike or swim, operate a snowmobile, an ATV or four-wheel drive motor vehicle. And then it also says, or to engage in other recreational pursuits. So that has actually been a pretty broad catch-all with that other recreational pursuits. We know that courts have interpreted that catch-all to include, a myriad of outdoor activities taking place on land, motorcycle riding, sledding, could even say like paintball on that land. So it's a pretty broad catch-all. So you're not limited solely to those items, but these are some of the main types of activities that, would get the protection of the recreational user statute. Another very key part of this is that the recreational user was granted permission by the landowner to enter upon the premises to engage in that type of pursuit and that type of recreational activity. So that comes to us specifically from the statute. Again, meeting the definition of a recreational user is a person to whom permission has been granted. So, you have to be doing a recreational activity to be a recreational user. You also have to be granted permission by the landowner. So that's an important key here as well. Importantly, to meet the requirements of the statute for the landowner to receive the immunity, the recreational user must not have paid a fee or other consideration to the landowner to enter upon the premises and engage in that recreational activity. So, no entrance fee, no exchange of, goods or services, other consideration, no payments being made there to come on to, to hike or hunt or camp or fish. Now there's one very notable exception. So again, the general rule is no fee, no consideration. One very notable exception in the statute is a lease payment. So again, recreational user cannot pay a fee or other consideration to the landowner, except a lease payment or fee is permissible. So again, this kind of came about in terms of if you have like a hunting lease. So that was a very kind of specific exception that was carved out into the statute. Another very key point here for immunity to apply is the recreational use. It's taking place on non-residential premises. So again, it's on a person's non-residential premises, and then premises are defined as all privately owned lands, ways, waters, and any buildings or structures thereon. So in general, we think about this getting back to the legislative purpose for this. This is applying to folks who have our woodland owners, our farmland owners, people who have these non-residential open lands, woods, fields, streams that are suitable for these types of recreational activities. Again, it's applying to those folks to allow others to come on and enjoy those activities as well. So again, just important to note, this does not provide any immunity if the injury to the person occurs on, in or around your home. So again, we could contrast, enjoying the stream out back versus, the pool in the backyard. Again, there's no immunity for injuries occurring in or around, the home or that area surrounding the home. Another point in the statute here is that the landowner in Ohio, our recreational user statute does not require that the landowner keep their non-residential premises or property open to anyone from the public who wishes to come on and use the property. Again, you don't have to treat your property as essentially to like a public park. You make the choice as to who you want to let on to enjoy those activities, but you don't have to let anyone who asks come on and enjoy those activities. So that's important here because the statute specifies that it's whether or not the premises are kept open for public use, or whether or not that owner denies entry to others. So again, does not have to be kept open at large. Also here, as we saw here, the statute keeps referring to an owner, lessee, or occupant of premises. So the immunity extends not only to the owner, but also to that somebody who might be leasing the property or occupying the property that gives, that might be the one who gives permission to the recreational user. So we see that reference here in the statute, a couple times that, first of all, the general immunity provision there, specifies owner, lessee, or occupant, and, the immunity outlined, applies to owner, lessee, or occupant. So, as we talk about an immunity statute such as this created by the General Assembly, one important point to keep in mind is that just the existence of this statute does not stop the filing of a lawsuit. So always remember, anyone can sue anyone at any time for any reason. But what this can do is it won't stop the filing of a lawsuit, but it provides an affirmative defense that you would then raise in the lawsuit. A very strong defense, I'll point out, given the language of the statute. But again, I just have to put the reminder out there that, if there's an injury and you are sued, and you believe that the recreational user statute applies to you, again, you must timely and properly respond to the lawsuit so that you properly bring that defense. Again, we'd say contact counsel immediately in the event of a lawsuit. And then just another point of just general point here is, again, regardless of the immunity statute, all of us know we want to take the time to ensure safety. Obviously, nobody wants to see an injury occur. So just some general safety tips. These are nothing spectacular, just kind of common sense. Periodically inspecting the premises where your recreational users, or even trespassers might travel, to see if there are any dangerous conditions. If you can, eliminate those conditions or repair them. If you can't, provide a warning against them. You can install protections, barriers, fences. You can post, again, those warning signs on those conditions that you just can't, remove or repair. And again, just keeping your property in good general repair. So again, just some common sense things that we should all remember, regardless of whether or not we may ultimately have immunity if there's an injury. Obviously, first step is preventing an injury if we can. Just a couple, I will go quickly through these to try to keep us on time. There's just a few examples of some cases of some items that the courts have found to be recreational use. Snowmobiler, sued owners of farmland and a contractor who dug trenches on the land for injuries sustained while snowmobiling. That was found there, it was found that the recreational user statute did apply and that the landowners were immune. Another case involving, riding a gator utility vehicle on the property, that was also found to be recreational use. Some of these cases also involve, accidents on city park land where this is brought into brought before court, and this was a sledding issue. Another motorcycling case was brought. So that is all that I have specifically as to the recreational user statute. So I'll stop sharing screen there, and that's kind of the broad overview of that protection that we have. So, Peggy, I think that might kind of segue into the talk of if we let people onto our property for hunting leases or other types of recreational leases, there's also some things we could kind of keep in mind.
Yes, I'm trying to share my screen now, gentlemen, if it says I'm not allowed to. So if you could change that. So
Thought I had you as a co-host, Peggy. Let's see what's going on.
it was not to be allowing me to.
Dave, can I chime in for a quick little plug
Sure.
request for Amy?
You got co-host permission. Maybe it's just because Amy was still sharing, Peggy.
I think I should have stopped sharing. I can see a bulletin, Peggy.
Yeah,
Oh,
I think you are
see it?
sharing. Yeah.
It is. Okay, it is there now. Okay.
Mhm.
All right, good. Someone had a question, I thought. Was someone trying to say something? Ross, was that you?
It was Mark. I was just going to
Oh,
ask
Mark.
Amy while you were loading up there to kind of hash out for everybody's benefit the sign postage program from the Farm Bureau, the $5,000 reward program, and how that works or something like that. But you're loaded up. Do it.
Okay.
Oh, no, that's fine, Amy, if you want to talk about that for a moment.
Yeah, just a short plug. Thank you, Mark. Yeah, we did increase that to $5,000 up from $2,500. So again, you can get those signs from your local county farm bureau offices, and be sure to post those on your property. So again, it's for if people are able to provide information that results in the conviction for some listed property crimes that occur on your farm. So again, be sure to visit your county farm bureau office and get a copy of your updated signs.
Thank you, Amy. I wanted to point out to everyone that we have a law bulletin on our website with OSU, farmoffice.osu.edu, that explains the law that Amy just presented for us, the recreational user statute. So that is available online for you. And as Amy said, there's an important exception there where you're leasing your land, you can still receive that immunity. And actually it was the hunting landowners, woodland owners, who were effective in getting the law changed a number of years to ensure that those who lease their lands can still have that immunity. So we wanted to talk a little bit about that situation where you may be leasing, and also point out that we have a law bulletin on that on our farm office site as well. Some thoughts about leasing your land for hunting. These thoughts would apply to other kinds of recreational leasing situations, but in that bulletin, I recommend some provisions to include in that type of a lease, a hunting or recreational lease. And I do want to make sure that going along with what Amy was saying about the importance of avoiding injuries, even though you would have this immunity, you do still want to make sure your property is safe for those who are leasing your woodlands for these types of uses. And especially when we're talking about hunting, a concern that I have is that possibility of having too many hunters on the land, maybe leasing to a couple of different hunters, or they're sharing a lease. My fear is that you could still have immunity, or you could still have liability if you don't take some precautions to properly manage how many hunters are coming on and off the land. And Amy, I don't know if you have any thoughts or experience with that, but that's one of my common concerns with this recreational user potential for liability.
Yeah, I would agree that that potential is there. I think I'm not aware of any specific instances. Fortunately, I'm not aware of any specific instances where that has come up, but I agree that would be a concern.
So there are some things you could do. You could designate where hunters should park so that when they do arrive there, they would know that someone else is there by seeing their vehicle. Or you could, parse out the times that they are allowed to hunt on certain days or certain weekends. A couple of strategies like that, just to make sure that that isn't you've taken care of everything else, but there's that one possibility where you might have some liability. That's how we attorneys like to think, right? What is that one way around what's there? So we offer some thoughts in this bulletin that I'm showing you here on the right on provisions to include in your hunting or other type of recreational lease. Are there any other thoughts, questions, Amy, we should address on this issue of recreational use or leasing before I go on to line fence law? Do you have any other recommendations that you provide for your members?
Well, I would say something that I know you've noted before, Peggy, is not necessarily needing to recreate the wheel in terms of the recreational user statute protection, but simply noting and acknowledging that that protection will apply. Maybe you may be referencing and the statute and noting the application of the statute.
Yes, probably the most frequent question I receive on that recreational user statute is, how do I give permission? And of course, if you can get your permission in writing, that would be preferable, or at least have a witness, someone with you who can attest to the fact that you did give that person permission if it happens on the fly. We've had some really strange requests on our farm, things that people want to do, like someone wanted to land a hot air balloon there, and it was 10 minutes before they needed to land. Or so if you don't have time to put something in writing, at least try to have someone there who could attest to it, or put it, make a note that this happened. I gave this person permission at this time on this day. But there's also that snowmobiling case that Amy mentioned. And that one, the landowner hadn't given express permission, but had allowed that use to continue, had seen it, let them go ahead and snowmobile across his farm, never tried to stop them. And in that case, the court said that's permission. That works for us in order to give you this immunity. But the preference would be to get it in writing or documented in some way.
Before we move on, we have a couple questions in the Q&A section. If you guys want to take a gander at those. The first one was from Jeannie. How are you covered for trespassers if you have to have given permission?
Yeah, and I think in terms of the recreational user statute that we covered, that's correct. That immunity statute does not apply to trespassers. It only applies to people that you have given permission to, that you can reference and document that permission in some way, that you could prove that permission in some manner. As Peggy was noting, there's some creative ways to do so, but if you can note that you've given permission. So yeah, essentially, it applies to people who are there with your permission, but it doesn't apply to people who are there trespassing.
And that creates some angst in our landowners. They really would prefer that it apply to trespassers as well. And so one recommendation we could give is, if you do have a common, frequent trespasser, you know who it is, you really don't mind too much that they're there, go ahead and give them permission and ensure that you move them out of that trespasser category into this recreational user category. But if you don't want to do that, if you really don't want them there, then you do not have the luxury of this immunity. Although what you do have is, a lesser duty. There's still a duty to keep them safe. It's a lesser duty than you would have for customers or someone like that. So beware that if you don't give them permission and use this immunity and they're there against your will, not with your permission, and they are in that trespass category, and you do have some duties to ensure their safety, The biggest one being if there's something that you know is dangerous that they will encounter, you had better do something about it. You had better warn them about it or do away with that danger. So landowners don't like to hear that one.
And thank you guys. And then our second question, we have a landowner from the eastern side of the state. He's dealing with ATV trespassers, and he would like to know what actions he can take as far as implementing physical barriers that won't negate this immunity clause.
Would you like to start that one, Amy?
Yeah, let me just take another quick look here. So I guess in terms of preventing trespass, because you're wanting to invoke the immunity clause, it kind of goes back to the previous question where if you give them permission, they can be considered a recreational user. If you don't, they're still a trespasser, and you'd have to just kind of basically approach it as that. If you really don't want them on your property, certainly contacting law enforcement. There are some heightened some increased penalties when the trespass is being done with an ATV. Again, that doesn't give you any special immunity based on your duties. You'd still owe a duty to them either as a known or unknown trespasser. Again, unless you gave them permission, which would kick them into that recreational user category. Any other thoughts on that one, Peggy? As far as it's really a tough one because you're either one category or the other, and permission is the key. And yeah, like you noted, there's that kind of disconnect between why do I owe an even lesser duty when I've given permission than to a known trespasser? But that's just kind of one of the features of the statute.
Right. And a common question we hear is, well, can I set a trap for them or do something to keep them off my land? And the answer to that is sure you can, but you'll probably be liable if they're harmed. Any kind of little, trap or I hear some really good scenarios, that involve nails and thin wires. And if you try to do those kinds of things to keep people off your property and they're not very obvious to those potential trespassers, then you could actually be liable for harming them. So if you do want to keep them off, you need to do some very, very obvious things and make sure that they know that there is something that could harm them if they proceed to violate your boundaries. So be careful about that as well. Are there any other questions? I can't see the question chat box in my display now. Did we get them all?
Yeah, I think we answered the two.
Yeah, I don't see any more.
Yep, I think
Okay.
I think we got them.
Okay, well, we only have 8 minutes remaining. So Dave and Ross, do you want me to talk quickly about line fence law, or would you rather just make sure that you have time remaining for any other questions that there might be on the trespass? And
I think we're pretty good shape. Our run a little long, but attendees I think can stay or go if they want. So I think that'd be great if you want to go ahead, Peggy, and we'll answer
Okay.
questions if they pop up. But I don't see any, so I would roll.
Okay. Well, you gave me this huge request to cover line fence law in about 10 minutes, which is just absolutely impossible. Because line fence law is one of our messiest laws that we have in Ohio. So what I'm going to try to do is condense it to some issues that woodland owners might deal with, but I'd be happy to answer any other questions, and I can point you to some other resources on line fence law. But it takes about a good half hour just to explain our Ohio line fence law. But the situations that I would think most common in a woodland owner situation would be one, you just want to maintain an old line fence that's in place. And this happens, very common. Those line fences fall into disrepair. And so who's responsible for maintaining that? The old law said that both adjoining landowners, adjacent landowners, were responsible in equal shares for maintaining that fence, but the law changed back in 2008, and it now uses the language of equitable shares. And so what that does is create some uncertainty between you and your neighbor as to what's equitable. It's a fairness test, and so if you can't agree otherwise, and many have chosen just to stay with the equal shares and the old custom that we have in Ohio, that as you look at that fence, the right half of it is yours to maintain, and your neighbor then would take his or her right half as they look at it. That's never been written into Ohio law. That's just a practice, a custom that we have carried on for years. And you can still do that. You can still agree between the two of you to maintain it in equal shares. But if for some reason your landowner next door doesn't want to maintain it at all, whether in equal shares or otherwise, then you could go to your township trustees or the common pleas court and ask them to order that neighbor to maintain their equitable share of the fence. And that would then, of course, require the trustees or the judge determining what the equitable share would be. So when they do interpret that phrase, equitable share, there is guidance in the line fence law that says, well, we look at the situation on a case-by-case basis, and we look at things like topography and water and who has livestock and who doesn't, and then we decide what's fair when we decide who does what proportion of the fence. Even under this new equitable shares rule, I find that most trustees resort back to 50-50, that it's, okay, you do this half and you do that half. There haven't been a lot of variations from equal shares since we went to this equitable shares rule, but that's the rule. So if you need help getting your neighbor to maintain an old line fence, your route would be to do that, to file a complaint with the township trustees or judge and ask a determination of the equitable shares, and then an order to maintain that fence. The other question that I hear a lot is removing and replacing one of those old line fences. I want to put in a new fence, and I want my landowner next door to play into that. Well, unless you took some actions to file an affidavit back in 2008 to kind of preserve that equal shares rule, the equitable shares rule is going to apply. And then there's another exception, and that is if the other landowner or one landowner removes a fence and didn't provide the required notice that is now required under the newer line fence law, and didn't replace that fence within 1 year, then the equitable shares rule does not apply. And in fact, that person would not be able to require any kind of contribution by the other landowner. And then situation 3, as I said, these are really complicated, and I'm sorry that I'm going through them so quickly, but in the interest of time, I'll raise them and see what questions we have. The other big change when the line fence law was passed or revised back in 2008 was how we pay for building a completely new line fence. And a completely new line fence is one where there hasn't been a fence documented before or preserved by an affidavit. So you just want to put up a new line fence on the boundary between you and your neighbor, you now have to pay all of that cost. There is no 50-50 equal shares rule on constructing a completely new line fence. So you pay for all of that, but you do have a mechanism available at law called the Affidavit of Line Fence Costs, and you can file that affidavit with your county court and note what it cost you to build that fence. You can also file an affidavit every year if you incurred any maintenance costs for that fence. And then if your neighbor decides, ooh, this is a nice new fence, I think I'll get some cattle, you can seek reimbursement through a reimbursement claim process and have them pay a proportionate share depending upon the age of the fence for that fence if they do indeed use it. And remember, that's only if they're using it for livestock. So it's your duty now to build a new line fence. And if you are going to build it for livestock, you'll have to build it in a certain way. But if they do use it later, you can at least have them contribute to the cost of that new line fence that you installed. And that's only for a 30-year period that would be effective. So those are the three big situations that I see most frequently. But I think it's important to note, and I may have mentioned this right at the beginning, that you may agree otherwise. Neighbors are free to make their own agreements about those fences on the boundary between their properties. They don't have to abide by the line fence law. You can make an agreement and put it in writing and file it in the county where that fence will be. And then that is going to be the rule that determines how that fence is constructed and maintained. So you're free to do otherwise when it comes to line fence law. And we have a number of publications. As I said, it's a tedious, kind of messy law to try to explain. So I've written several guides and law bulletins on this, and also have some examples of some of the agreements that that come into play here when we're talking about line fences. A big bulletin, one that's often used, you can see there on the right, is the guide for township trustees, because many of them don't understand procedurally how these things work. And in there you can find information about if you do want to file a line fence complaint. We explain all of that in that bulletin. So that was a little bit quick, but let me see, are there any questions about line fence law?
There are 3 questions in the box. There's one about surveying that you might want to take at this point. The other 2 are one's about water bodies and the dangers associated with them. So the one about surveying is just asking for what is a reasonable cost for that. And I don't know that anybody on there's so many variables willing to take that, but if anybody wants to give that a shot.
Sure. I mean, surveys are going to be very dependent upon the size of the property, the age of any prior surveys, the age of a prior legal description, whether that has to be updated, and most of those do if they're very old now under the new standards. So there are definitely a lot of factors that come into play. Amy or James, do you go by James or Jim? If either of you have any comments, feel free to chime in.
Jim, you're muted. I see you're talking, but you're muted, so I don't know if you can hear us. Mark might have some insight on that as well. Mark deals with a lot of property owners and boundaries.
In the absence of Jim being muted, he's going to have to flip that, of course. But from what I've dealt with, the Professional Land Surveyors Organization is where I send all my landowners to get a professional land surveyor, first off. But that group, talking to them, it depends on the evidence that is available to recreate those lines. And the farther they got to go to find good, hard evidence to start with is what really runs your cost up. So it's really hard for people to understand as landowners to say, surveying 40 acres is not always the same charge. The next 40 acres may not have a good survey anywhere close. They may have to go 3 miles to start rebuilding that line. Because again, a professional land surveyor's job is to either place a new line or to recreate the line that was originally there. And again, kind of helping out too. Help me if I'm wrong, guys, on the legal side of this, but only a professional land surveyor can place a pin. Only a professional land surveyor can remove or move boundary line pins or markers. And this is kind of what I was hinting at earlier, like Virginia Military Survey. A lot of that, unfortunately, goes to this tree or that tree or this fence post. When it goes to that tree, who can legally remove that tree? It is not the logger. it is. A surveyor has to be able to come back and put something there and so forth.
I see your mic's on, Jim. Do you have anything to add to that?
I really, no, I don't. I know that I had to reconstruct a line in Benton County that, and guy had to go a long ways to find a benchmark to ratchet off of it.
I'll throw one more quick note in there on that to help you guys out as landowners, and I'm sure all three of my legal colleagues here today will back me up on this. Getting your survey done is one thing. Getting it filed at the courthouse is a must, and it is not a guaranteed thing. When you get a surveyor to do a survey, you have to make sure it gets filed at the courthouse.
Mm-hmm.
And that's where that legal description becomes very important in making sure it complies with the standards.
Okay, I got a question from Rod about lakes and ponds. There are inherent dangers related to water bodies. Do landowners have to put up danger signs around all water bodies and warn people of dangers, or is it understood that they are dangerous?
We have this wonderful thing in the law, open and obvious conditions exception. And so what that says is those dangers that are open and obvious and known to the reasonable person to be dangerous, we don't have duties for as landowners to warn people about those kinds of conditions. The concern I have, though, even though we have that, is that there could be things in and around the water body that could be dangerous that a person might not expect. And so I think you'd need to be careful about that and warning about that. And then, of course, children. I don't know if anyone, Jim or Amy, if you want to talk about children and the special concerns that we would have for children, whether they would understand an open and obvious danger in the same way that an adult would. But so if there are children around, I would take additional precautions for children as well.
Okay, there is one question from Robert in the chat box. If there's no livestock on either side of the fence, must the fence be maintained, if only to establish the property line? No,
there's no legal duty to maintain. It's kind of a sleeping obligation, legal obligation, where it's only a duty if your neighbor files a line fence complaint and says you should be maintaining. Otherwise, there's no legal duty to maintain your fence. If they do file a complaint, then you will have to maintain it. And the old language was to a point where it's capable of turning livestock, but that language has been removed by way of the changes to the law. That was through case law. But if there is a complaint and they say you need to maintain it, there might be a requirement within that complaint that you maintain a certain type of fence if it's for livestock. So you may have to maintain an NRCS approved fence if it's for livestock or whatever the decision might be on that.
Just to add to that, if there is no livestock, it's a lot easier. It may not be a legal requirement, but it's a lot easier to maintain the markings on a boundary than it is to reestablish them, and it's a lot cheaper. So if you have an established boundary out there, maintaining the markings is going to be in your best interest in the long haul.
And for Ohio Forest tax law, that is a requirement that it is marked, painted, or again, the fence has to be able to, we kind of go to the old rule, it has to be able to turn livestock. It can't be parts and pieces of the fence. It has to be something obvious. But boundary painting and fence line, I'm sure Peggy will tell you, are the fence and boundary painting are kind of separate, but they're together. So.
Okay, I got a question about the document that DNR-Division of Wildlife provides for hunters. I tried to find that and put it in the chat box, but it's not easy to find on Division of Wildlife's page. But you guys want to address that form and how that works?
Are you talking about the permission form, David?
I believe that's what they're talking about.
I think it just restates what the law is.
Yeah, it clarifies that they have to have your written permission and carry that with them and give some guidance on, what you should do, require of your hunters that, that they be properly licensed. And
I'm throwing this in here.
It also paraphrases the immunity piece that,
yes, yeah.
And
And we should note
I've
that
got
in
it right
addition,
here.
we should note that in addition to the recreational user law, when it comes specifically to hunters, the hunting law says that anyone who doesn't have your written permission, you are not liable for if they are harmed on your property while hunting without your permission. So that's where the trespassing hunter comes in, I guess.
Yeah. I use that form personally, and I like it just because it's an official document. I think it's got carbon copies, so they can have a copy, you can have a copy, and it's just I think it's an easy thing to do if you can get the form, and there's Jim's
There it
one
is.
up.
yeah, it helps, that isn't necessary. It helps both the landowner and the hunter. Of course, the landowner isn't absolutely required to get it in writing, but this is great evidence that they gave permission, so it notes that. And of course, obviously the hunter has to have it in writing there. So yeah, on the landowner side, if you, like Peggy noted, if you give permission, this is a great way to document that for purposes of invoking the recreational user statute. If they're caught and they don't have that and you didn't give permission, then like Peggy noted, you have an alternate way that the landowner is protected there.
And what was that again, Peggy? The alternate way?
In the hunting law, there's a statement that where I can point you to this site if I pull it up here, where it says that they have to have permission, and then after that it says anyone without permission, the landowner has no liability for.
Well, that takes care of a certain class of trespassers, doesn't it?
Hunting trespassers without permission. Yep.
And we've got one more question in the box. I want to have you guys take that, and then we can hang on and answer questions as long as they pop up, but I want to kind of formally wrap it up. Can you read that, Amy? I don't know. It might be easier for you to just look at it. It's in the question and answer. Or Jim, you might look at it too.
Whoops.
Oh,
I can-
I'll take this one. Yeah. Send me your email address for the owner advocacy group. There's no reason why trespasser immunity couldn't be something that we look at.
Yeah, and if I'm understanding that, that's essentially wanting to change kind of the common law on your duties to trespassers, change it statutorily. It's kind of what I'm reading from that question. And I think, in terms of extending that, in a little ways to with the recreational user statute.
That one should be an easy sell.
Yeah, we hear a lot from landowners about a desire to change that, and a statute could do that. Our courts often have to fall back on court cases because we don't have clear statutory guidance on some of these types of visitors, and many other states have changed to a statutory single standard for any type of person on your property. But in Ohio, we still go back with, is it a customer? Is it a trespasser? Is it a child? Is it
Just say everything. Yeah.
one standard, and that is that you have a duty to take reasonable care to protect, foreseeable visitors on your property from harm. And so that's where we kind of knock the trespassers out, because they're not the kinds of foreseeable visitors under most of those kinds of state statutes that would be that you'd have that duty for. So we could do that in Ohio. We just haven't. We're one of the holdout states that hasn't gone to that kind of approach to premises liability.
Okay. Well, I really want to thank my guest speakers today. Mark Rickey from Division of Forestry, James Savage, Amy Milam from Ohio Farm Bureau, and Peggy Kirk Hall. It was a great discussion and appreciate it. We had about 35 people on, I think, for today. We had a lot more registered, but on sunny days, I think some people decide to do other things. But these recordings will be available. I'm going to paste the website into the chat box, and that's where we do all of our day in the woods information. And we'll post any resources that our speakers want to share. I'll do a post and put those all in one spot. So again, we appreciate it. Hopefully we got all the questions answered. I'm gonna just look to make sure. And I see one more from a Craig. It's asked about liability. Do we have if my local police will not pursue trespassing as a problem? I don't know if Peggy or Amy want to address that one, or Jim.
That's not a you problem, that's a them problem.
Yeah.
And I guess I would also just, chime in too, if it's a known trespasser, potentially looking at it again as, a trespass in the civil sense. But again, that can be difficult as well.
Okay, well, I really appreciate all the help, and also my helpers out there, Julie and Ross and Jess, for coming on board and just helping manipulate Zoom today. So really appreciate it. Everybody enjoy the weekend, and hopefully you'll get to spend some time in the woods. Oh, and I was muted during that, wasn't I?